welcome. We apologize for technology failing us. And without further ado, I am going to hand over to our lawyers and they will facilitate this session. Please put any questions you have in the chat. And so we'll have the presentation. And then once the presentation is done, we will then have a question and answer session. So any questions that occur to you while the presentation is happening, kindly put them in the chat. Okay, over to you, lovely ladies. Perhaps you can introduce yourselves and then start the session. Thank you very much.
Thank you, Vazi. Thank you again for the invitation to run this training. Most of you already know me and my colleague Laura. We are from Modulo, which is a specialized legal consultancy focusing on international employment law, particularly within international organizations and international civil servants, in the field of international civil servants. Modulo was founded by myself and Neha Dubey, who is a barrister in Australia. And we offer of legal expertise and advice and services tailored to the unique challenges faced by international civil servants and international organizations. As I said, together with me today is Laura Papasodaro, who assists at Modulo with daily work, providing legal research and drafting. Laura is not yet a licensed attorney, but she has gained a very good expertise in international administrative law in the past year. As I said, I welcome everyone to this session offered by FICSA, which focuses on the most recent developments in the field of international administrative law. Over recent years, restructuring has become an increasingly prominent trend across international organizations. This approach is often seen as a straightforward and necessary strategy for organizations to reduce costs and realign their operations in response to evolving political and economic pressures. The urgency of restructuring has been particularly amplified by recent financial constraints, such as the freezing of US funds in many international organizations. This has created a significant budgetary challenge, especially regarding staff expenses, which typically represent a large portion of operational costs. As a result, downsizing and cost-cutting measures have become critical priorities for these organizations to maintain their functionality and fulfill their mandates in an environment of limited resources. Given these dynamics, it is clear why restructuring is a hot topic today, drawing attention from all levels of international organizations. This training aims to provide you with a comprehensive understanding of the legal, administrative, and practical aspects of restructuring within the international civil service, equipping you with the knowledge to navigate and manage these changes effectively. As Vazi said, please keep your question and put your question in the chat, and we will have a Q&A session at the end of the presentation. So today we will go through the following topics: the right to restructure, the limits of restructuring, the consequences of restructuring, how to contest a decision following restructuring, the case law and the main interpretation of the administrative tribunals on restructuring, practical tips for you as staff, frequently asked questions that we collected among international organizations and in different trainings. And finally, as I said, we will have a question and answer session at the end of the presentation. So I think we can start with the first topic. I hope we have everyone now attending. I see there is still some people joining from the other chat, but and please put your microphone on mute. Thank you. So I will go ahead with the right to restructure. So the main point here to remember is that international organizations enjoy a very broad discretion when it comes to restructuring their services or departments. This principle is firmly established in case law from both the ILO 80 and the UN appeals tribunals. The discretion of international organizations in this respect is very broad, and the purpose itself of the restructuring might be very difficult to challenge. The LOIT stated, according to firm precedent, decisions concerning the restructuring of an international organization's services such as a decision to abolish a post, may be taken at the discretion of its executive head and are consequently subject to only limited review. For this reason, while it is incumbent upon the tribunal to ascertain whether such a decision has been taken in accordance with the rules on competence, form, or procedure, whether it rests on a mistake of fact or of law, or whether it constituted abuse of authority, it may not rule on its appropriateness, since it may not supplant an organization's view with its own. The UNAT stated that the appeals tribunal will not interfere with a genuine organizational restructuring, even though it may have resulted in the loss of employment of staff. The organization has the right and power to restructure some or all of its departments or units where it considers such necessary to meet organizational needs and priorities. Such restructuring may justify the termination of employment on grounds of operational requirements. Therefore, organizations have the right to freely restructure. Their discretion in restructuring is extremely broad, and the purpose or appropriateness of restructuring is generally not subject to challenge. Moreover, we should know that staffing plans or policies or proposals for new structures are not an administrative decision and therefore are not subject to a challenge. The decision you as a staff member can challenge is that one directly impacting your rights. So, for example, the abolition of your post following the restructuring, the transfer to a different position, and so on and so forth. We will see this later, of course, in the presentation. But the main point to remember is that the decision of an organization to restructure is not per se a decision that can be challenged. So only the direct effects that such a decision will have on your employment rights is the decision that you can challenge. I will now pass the floor to Laura to give you an overview regarding the limits of restructuring, because I mean, it looks like that, you know, restructuring can be done in any form and in any way, but that's not the case, fortunately. So Laura, please.
Thank you. So hello, everyone, also from my side. I hope you can hear me well. The case law of administrative tribunals is very clear and consistent on what can be subject to the tribunal scrutiny in case of restructuring. We have included in the slide some judgments that are relevant to the limits of the scope of review in part from the part of the tribunals. In short, in cases of termination or non-renewal of contracts due to restructuring, the tribunal does not evaluate the merits or the necessity of the restructuring itself. Instead, they will only review specific legal and procedural aspects. Specifically, the tribunal will examine whether the decision was taken in line with the rules of competence, form, and procedure, whether there was a mistake of fact or a mistake of law, and whether the decision constituted an abuse of authority, was arbitrary, or was influenced by bias, prejudice, or any other improper motive. Additionally, the tribunal assesses whether the administration has acted fairly, justly, and transparently throughout the whole process of restructuring. However, the lack of fairness alone may not be enough to overturn a termination decision if all other procedural and legal standards were otherwise met. So the limited scope of the tribunal review highlights the importance of awareness from the outset in any restructuring exercise. It is crucial as a staff member to compile and understand the rules and regulations that are governing the restructuring process and to maintain proper documentation of all these rules and communication. So all communications and justifications given by the organization related to the restructuring process should be collected by the staff member and organized in a clear file. This will help on one side to make the administration or the organization accountable and transparent in their communication, and on the other side will provide also the necessary evidence to challenge any consequential decision, as we will see, as Ludovica mentioned, for example, the termination or non-renewal of contract as a consequence of restructuring. So in short, while restructuring is a broad discretion of the organization and may be a valid reason for termination and non-renewal. It must always be carried out, of course, properly and with respect for both legal norms and also the dignity of the staff members affected. I will now hand over back to Ludovica, who will look into what are indeed the possible consequences of a restructuring exercise.
Thank you, Laura. So yes, we will see the consequences of a restructuring. We decided to provide you some case law, which is, our, let's say, leading authority in this specific topic. The ILO-AT in judgment number 2510 considered that international organizations necessarily has power to restructure some or all of its departments or units, including by the abolition of posts, the creation of new posts, and the redeployment of staff. The LOAT in judgment 2907 stated that the LOAT has also held that although international organizations may undertake restructuring by reducing or reassigning their staff, each and every individual decision adopted in the context of such restructuring must respect all the pertinent legal rules, and in particular the fundamental rights of the staff concerned. As we said, there is not a right to contest the decision to restructure or reorganize. There is a right, however, to contest any administrative decision stemming from it and having a direct impact on the staff members. This can be the termination of contract for redundancy or the abolition of positions or the non-renewal of contracts. So we will see now in turn these three main legal concepts, let's say redundancy and abolition, the contract expiry and the non-renewal or the signature of a new contract. For what concerns redundancy and abolition of post, they entail only a limited review for the following specific reasons. Hidden motive, abuse of authority, and the disregard of the international organization law. The termination of a staff member's contract for reasons of redundancy is generally discussed in terms of abolition or suppression of posts, albeit for reasons of redundancy. The actions of the organization must be consistent with general overarching requirement of fairness. Where the written laws of the organizations are disregarded or ignored to the detriment of staff members, then the organization clearly cannot be said still to be acting with fairness. The tribunal has consistently held that there must be objective grounds for the abolition of any post. It must not serve as a pretext for removing staff regarded as unwanted, since this would constitute an abuse of authority. There's a sort of landmarking case of 1976 on abolition of posts. It's Garcia de Muniz against FAO. And in a relevant part, it states that although the Director General enjoys discretionary authority in taking measures which entail abolishing a post, his decision is not fully free from review by the tribunal. It may be quashed if it violates a rule of form or procedure, or if it is based on an error of fact or of law, or if essential facts have not been taken into consideration, or if it is tainted with abuse of authority, or if a clearly mistaken conclusion has been drawn from the fact. In particular, the tribunal will find that there has been abuse of authority where the abolition of a post is motivated not by relevant and objective considerations, but by a desire to remove a staff member for whose dismissal there are no lawful grounds. This is very important to remember. In another case, V against FAO, FAO, the LOAT stated that the tribunal can only examine the circumstances surrounding the abolition of a post for the limited purpose of whether there has been an abuse of authority, which entails consideration of whether the decision was taken for an improper purpose. Regarding a contract expiry and no renewal of contracts. So contracts are allowed to expire. There is no expectation of renewal on fixed term contracts. We will see that also later in a bit of a broader context. But this is usually the most used methodology to implement restructurings, namely to let fixed term and temporary contract expire in order to free positions without applying redundancy packages or awarding termination indemnities. This type of contract do not carry any expectation of renewal. Hence, even if procedurally they could be contested, it would not make much sense to do so, even if they have been renewed several times in the past, because it's, you know, there's no expectation of renewal, and this is written in all, you know, fixed term contract, as you probably all know better than me. If staff are asked to sign a new contract to retain a position in the new organizational structure following restructuring, it is very important that they receive a transparent information before signing a new contract with new limited benefits. For example, it should be clear that if you sign a new defined duration contract, a fixed term contract, you would most likely lose your entitlement to termination indemnity if your contract expires and it will not be renewed. So you cannot keep the entitlement for the future. Organizations are progressively eliminating contracts of indefinite duration for this specific purpose, which is to have the flexibility to discontinue contract without resorting to termination and with consequent payment of indemnities. It is unfortunate, but that's, you know, very much the trend right now. So. As I said, we will go back to some of these concepts later on. For the time being, I will pass the floor to Laura to explain to you how to contest a decision following restructuring.
So the process for contesting a termination or a non-renewal contract decision is the same that is used to contest any other administrative decision. I know that many of you are already familiar with it, so I will keep it as brief as possible, but we could have not skipped this entirely. As you will know, the paths vary very much from one international organization to another. However, there is a common principle which applies to all of them. It is that all internal remedies must be exhausted before being able to bring a case or a claim before an administrative tribunal. It is essential. The starting point is the staff rules and regulations. So it is essential to check staff rules and regulations to see the specific procedure that your specific organization follows. We have included some examples in the slide with some organizations members of FICSA. In any case, very important is always to, when you look at staff rules and regulations, not only looking at the procedure per se, but also at the deadlines. You will all know that missing a deadline can be critical, and once a deadline is missed, unfortunately, there is not much more that can be done. Now, as it concerns the process, although, as I mentioned, the procedure varies from one organization to another one, the structure is often similar. First, there is the possibility to engage in mediation. In most of the organizations, it is optional, but in others, it may be a mandatory step before being able to proceed further. The first real formal step is usually the internal review, which typically involves sending a request for administrative review to the director of the organization. The purpose of this review is to give the administration the possibility to have a second thought on their own decision and think whether they want to review it. In practice, we all know that these decisions are rarely overturned at this stage. Most organizations require timeline. They have a deadline of 30 or 60 days from the notification of the decision to ask for a review. Others have different times. So again, important to refer to the staff rules and regulations, and important not to miss the deadline. The next step in some organization is an additional internal step, such as an appeals committee or a board of appeals or similar bodies. Others do not provide for this extra internal step, and they refer direct to the administrative tribunals. Only once and after all internal avenues have been pursued and concluded, can a staff member bring their case before the administrative tribunals. As you will know, there are two main tribunals, which are the International Administrative Tribunal of the International Labour Organization and the tribunals of the UN, which are the Dispute Tribunal on a first layer and Appeals Tribunal on a second layer. They are also subject to strict deadlines, so again, it is important to keep those in mind. Some organizations, as you can also see on the slides, have also their own tribunals. Examples are, for instance, the World Bank or the European Bank for Reconstruction and Development or the Organization for Security and Cooperation in Europe. As I mentioned, there are samples on the slides, or you can refer to your own staff rules and regulations. I hope I kept it brief enough. Next, we have looked now at how to get a case before a tribunal. Now we are turning into what tribunals have actually said about restructuring over the years. Before, we saw that tribunals only have a limited scope of review, including things like procedure and legal errors. And now we are looking at what they have been saying substantially. From decades of case law, we can extract a sort of set of duties that international organizations must observe during restructuring exercises. So we have included some of them in the slide. First, there is a general duty to give notice and reasons. Tribunals have consistently held that organizations must provide adequate notice and detailed reasons when a post is abolished and when any resulting termination decision is made. For instance, the ILO-IT stated, and I quote, "An organization must give staff member notice within the required time and sufficient reasons for the decision to abolish their post and for any subsequent decision, including the termination of their appointment." In another judgment, the same tribunal stated, and again I quote, "The decision to abolish a post must be communicated to the staff person occupying the post in a manner that safeguards the individual rights. These rights are safeguarded by giving proper notice of the decision, reasons for the decision, and an opportunity to contest the decision." Therefore, in sum, timely and clear communication is key. In practice, staff should be informed as early as possible, and at best, the organization would organize town hall meetings or informative sessions to provide staff members with all available information, reply to questions, and be as transparent as possible. This, of course, allows staff members to be well informed and in a position to weigh their options, whether they want to apply for opening posts, whether they want to engage proactively with HR about reassignment, or they want to consider departing the organization with termination indemnity. A second principle we can extract from the case law of tribunals is the need to always give objective grounds. We touched already upon the fact that there cannot be an arbitrary motive behind, but specifically tribunals have repeatedly affirmed that any decision to abolish a post must rest on objective and verifiable grounds. The abolition of a post must not be used as a pretext to remove staff members that are regarded as undesirable. The test that the tribunal will apply will not merely be check whether the post was indeed abolished or not, but whether the reason for the abolition of post were in good faith, were supported by evidence, and were not hiding any improper motive. A third principle is that of duty to explore reassignment, very important and very consistent through judgments. Administrative tribunals clearly stated that an organization must actively explore reassignment opportunities before terminating a staff member whose post has been abolished. So the tribunal established a general principle that I quote, "An organization may not terminate the appointment of a staff member whose post has been abolished without first taking suitable steps to find him alternative employment." So the tribunal also held that flawed reassignment process resulting in the deprivation of an opportunity to be reassigned constitutes a loss of opportunity, and that loss of opportunity justifies an award of material damages. In practice, it's not enough for an organization to passively notify staff member of vacancies. They must be active and engage in supporting reasonably staff members, including with timely communication and with career counseling. Some organizations go even a step further by recognizing the need to facilitate reassignment through training. An example is the European Bank for Reconstruction and Development that has a rule which states the bank may provide the staff member with appropriate training if such training will facilitate their selection for an existing or known prospective vacant position. So this reflects a very forward-looking approach that prioritizes not only the rights of the staff member, but also the career development and their employability during this transition process. A fourth principle we can extract is about changes to acquired rights. So tribunals held that a staff member acquired right cannot be modified unilaterally. Any changes to contractual terms, particularly regarding benefits, salaries, entitlements, or status, must be based on a staff member informed and voluntary consent. Typically, this is done through signing a whole new contract. So on this point, it is also important to note that tribunals considered that cost savings alone do not justify breach of contractual employment rights. So while budgetary constraints and the need to achieve cost savings may be valid factors driving restructuring, the mere desire to save money is not enough to justify undermining established contractual standards. Now, based on everything we have said and seen until now, I hope it was not too much. I will hand over to Ludovica, who has a series of practical tips for any staff member involved in restructuring.
Thank you, Laura. Yes, so we come now to the, let's say, more practical advice of our presentation, and we will see then also the most frequently asked questions that we have received in the past years. A very important aspect to always bear in mind are the key dates of a restructuring. So the date the clock starts to run is the date you receive a written decision or notification about what is happening to your position, not when you are first informed of a potential restructuring. As I said before, you cannot challenge the idea or the decision to run a restructuring, but of course you can challenge a decision that is impacting directly your rights. Remember the timelines for the dispute process. Always check your staff rules and regulations. The non-compliance with time limits is one of the main causes of dismissal, both at the internal appeal level and at the external tribunal level. It's also important to keep a documentary record of representations made by your organization to you. Participate to town hall meetings, keep record of the emails that were sent to all staff with respect to restructuring. Keep note of the meetings with your supervisors. Send, for example, a follow-up email to confirm your understanding and what representations were made to you during a meeting with the subject restructuring or reorganization. What to do during a reassignment period. The duty to reassign is with the organization, but doesn't mean that you should just sit back and relax and wait for a new position to come to you. Look for other positions, secondments, loans. Consider, for example, if there is scope for interagency transfer and other, potential options that you would like to explore. Be proactive, update your personal history, your CV, keep in touch with HR and propose, suitable vacancies to be considered, if any. Always try to be proactive with human resources, and if you see that there's a possibility for you to apply for a vacancy. Staff on reassignment should usually only be reassigned to equal or higher positions. However, you can consider a lower position if you really want to stay on board with the organization. Consider as well whether you can ask HR for appropriate training during the reassignment period. As we've seen before with Laura, there might be, the possibility to train you and to acquire the skills that you would need to apply for a specific position that you think would fit for you. And remember to raise the opportunity to be trained with HR, raise the issue early on in the process. Don't wait until the last minute. The requirements for a legal case, as I always say, is unfortunately unfair does not mean illegal. So you always have to consider how has this exercise impacted your employment rights. You have to establish a breach of procedure, a lack of transparency, and misrepresentation. It's difficult to do so when you don't have a legal framework. The breach of the duty of care on its own is not sufficient. As we have seen before, you have to demonstrate that the restructuring was, for example, carried out ad personam, was targeted to you, and was ill-driven to harm you and your employment rights. Always try to have realistic expectations. Be flexible if you want to keep working within your organization. Try to get explanation about why the restructuring is happening. It has to be linked to more than just financial savings, although, of course, this is always, the main reason. Could have to do with strategy or future or organizational needs, which is like the most used, let's say, excuse or justification for a reorganization. And of course, you have to accept that, this process might bring uncertainty to the workplace. As we have a lot of staff associations members here and representatives, what the staff associations can do in cases of restructuring and reorganization. So the starting point is that the staff association probably has no power to affect the actual restructuring. This is, as we said several times, entirely at the organization discretion. So the focus should be on ensuring that this restructuring is done in a legal and proper manner, transparently, and without any scope for abuse of authority. The number one priority should be the dissemination of information. This means, to constantly push management to share procedures, the methodology or policy that they are following to do the restructuring. Most likely, this is not formalized in a written document, so you could, for example, get involved in drafting, the methodology for the restructuring, or in reviewing the methodology of the restructuring, because you need to make sure that such guidelines or document cover topics such as the timeline for implementation, what the options are for staff, how the information will be disseminated, like through town hall meetings, individual staff meetings, and this kind of things. Of course, depending on the size of this, restructuring. A very good idea is always to organize a town hall meeting where management are forced to give a presentation and answer, staff questions, which might, provide clarity to staff. Equally, there is, you need to be able to advise staff on the difference between legal and illegal, so you can manage, staff expectations from a, staff association perspective. Also, it's important to ensure consistency of the criteria used in restructuring, the transparency of information, and due notice to staff. As Laura said before, the earlier those restructuring are communicated, the better it is, because this allows staff to get accustomed to this new period of uncertainty. As I said before, we will now see some frequently asked questions that we collected in the past years. And I leave the floor to Laura with the first, let's say, three main topics. And I will then explain to you further frequently asked questions.
Thanks. So duty of care is a question is always asked. In the context of international organizations, the duty of care has developed considerably over the past decades. Originally, it was meant mostly understood in terms of physical safety and ensuring that the workplace was secure. More recently, it has been developing and it evolved to include also the psychological and emotional safety, as well as fairness in how staff members are treated. The case law of international administrative tribunals now makes clear that there is a duty of care, which includes the obligation to act in good faith, to communicate transparently, and to respect the dignity of staff members. For instance, the ILO-IT held that staff must be treated with respect and consideration, that organizations should not cause undue personal harm or distress when it can be avoided, and crucially, that staff must always be informed in advance of any decision that may affect their rights or interests. This sets a clear legal framework that must guide the organization during restructuring process. Organizations must ensure that communication is proactive and that they provide channels for staff to raise concerns and to contest the decisions, as we have seen. Duty of care means also providing staff members with an adequate mechanism of recourse. A second question we are often asked, and we touched already shortly upon this, is about changes to employment contracts. Changes may be, for instance, moving from an open-ended contract to a fixed-term contract, or being asked to accept a lower grade position. The legal position is generally very clear on this. An international organization cannot unilaterally change the essential terms of a staff member contract. That includes things like the contract duration, the post title, or the grade of the staff member. If a change is proposed, it must be voluntarily accepted by the staff member and typically accepted by signing a new contract. If a staff member is not willing to accept a downgraded role or to change the nature of their contract, they have the right to decline, of course. This may trigger the termination of the contract, however, but in the case of termination of contract, they should be entitled to the benefits associated with redundancy or termination, such as the termination indemnity or the separation payment. A third question is about reapplying for jobs. This is something that is quite common in large restructuring exercises, where entire units or departments are being reorganized. The idea is to reduce headcount while giving existing staff the opportunity to compete for the new or revised roles. Legally, this is not a problematic as long as due process is followed. Staff must be informed of the process and the selection criteria, and the process must be transparent and non-discriminatory. And enough time must be given, of course, to staff members to allow a meaningful participation to the selection process. That said, problems can arise when the job descriptions are changed in such a way that the original incumbent is now deemed unqualified for the position, particularly when those changes are based on new academic requirements, additional language skills, or experience thresholds that weren't previously required for the same position. In such cases, staff may be able to challenge the decision, especially if they can demonstrate that they could have acquired the new skills with reasonable training, or if the changes were unnecessary or excessive. However, these cases are very complex because, as we have seen, tribunals generally grant organizations a very broad discretion in defining their operational needs and their priorities. We'll go ahead and give back the floor to Ludovica for the next batch of frequently asked questions.
Thank you, Laura. I just wanted to raise a technical issue before we conclude the presentation. I concerningly noted that we have only a few minutes left in this meeting. I mean, I got a pop-up saying that this meeting is 60 minutes. So I would say that if the meeting should end, I think we should all rejoin with the same link. But I'm not a technology expert here, so I
don't think there's an end with Teams. You can go. I mean, you can go.
Yeah, I think it will not be a problem, but otherwise
I am
we'll
just
try
saying
on
that
the
because
same.
I've seen a disclaimer that it's a 60 minutes meeting, but let's hope for the best. Okay, sorry. Yes, we have other frequently asked questions that I would like to go through with you, and then open the floor, of course, for your questions. So as we said before, in most international organizations, once a position is formally abolished, staff are typically given a notice period of several months, during which time they enter a reassignment phase. During this period, the organization has an obligation to make reasonable efforts to reassign the affected staff to a suitable position. If no such position is found, the staff member's contract comes to an end and termination indemnities apply. Related to that is a common question about whether there's a trade-off between the right to reassignment and the right to termination benefits. These are not mutually exclusive, but sequential. The right to reassignment kicks in first once your position is declared redundant. Only if the organization cannot reassign you, or if you reject all reasonable options, does the right to termination benefits arise. So you don't lose your right to indemnities by going through the reassignment phase, but you may lose it if you choose to accept a new post instead of exiting the organization. During the reassignment after redundancy, we got this question several times, and staff member asked us, do I need to accept any alternative position offered to me? What happens if I do not accept such alternative positions? I mean, of course, you don't have to accept a position that you don't want or that you don't like. So you can set up a meeting with HR, for example, at the beginning of the reassignment period to discuss your grade, skills, and general profile. It might take HR more than one go to find you the right position. Ultimately, if you do not accept the positions being offered, your contract will come to an end, and that's it. You get your termination indemnity and depart the organization. A related question to that is, if I leave the organization for another job outside the organization, will I still receive the separation payments? The lump sum, the termination indemnities, the annual leave, and so on. Well, your entitlement to this kind of separation payments is based on what has happened at the organization. So if following the redundancy decision, they are not able to reassign you and your contract ends, then of course you're entitled to termination indemnity payments. If they offer you a voluntary separation, for example, these amounts should be part of the separation package. However, if you're leaving the job voluntarily because you don't want to wait and see how the reorganization works out, you do not have any entitlement to a termination indemnity because you will be treated as the same as anyone else who resigns. So, if you resign during the restructuring, then of course it's treated as a resignation. Another hot topic is a mutually agreed separation or voluntary separation. We're often asked whether these can be offered to some staff and not to others. The answer is yes. Organizations have discretion to determine when and how such schemes are implemented, often based on budgetary or strategic needs. There is no legal obligation to offer a package uniformly across the organization or even within teams. Obviously, from a practical point of view, there should be consistency within a team, but this is not a legal requirement. These are, of course, confidential agreements that staff members conclude with the organization. So we do not have a way of knowing what is offered to each staff member. In our experience, whatever is offered still has to be in line with the internal law of the organization. So the most that could be negotiated would be the calculation of the termination indemnity. It is mandatory for staff members to accept the position assigned during a reassignment period. As we said before, you don't have to accept the first thing that is offered to you. You can, discuss with HR, and it might, take some time to find the right one. And if you don't, you're under no obligation to accept, and you will separate with separation, termination indemnities and separation entitlements. Another question, and then I conclude, if whether the organization can use restructuring in lieu of performance management. It might seem this way sometimes, or that, let's say, this might be the practical effect of restructuring. In theory, these are two separate and unrelated processes. As long as a restructuring follows the requirements of giving adequate notice to the employee and making reasonable effort to reassign, it is permitted. Lastly, we have been asked whether consultants do have any right during restructuring and a reorganization, and unfortunately the answer is no, because consultants generally are not staff members. So the employment rights arise between the consultant and the contracting agency. So that's not. I mean, they are regulated under different terms and conditions. So those were the, let's say, frequently asked questions that we have collected over the years. And I now open the floor for questions. I'm not sure I see questions in the chat.
I think the chat is not working. Just to add another...
Yeah, just to add another layer of complexity to this meeting. Very good.
It's working for someone. I
cannot see it, unfortunately.
I see a message.
Ludovica, can you see?
I see only one message from Christina, who said that there were still people in the other meeting at 2:08.
I can read some of them that I can see. So let me read the ones that I can see, and then we've got hands up as well. So I think let's do them. So the first one is from Antonio, and it says, what to do in case they don't formalize.
Perfect. Do you want to proceed that we go through raised hands, or Christina, you want to read first the question? That's maybe better if you read the questions collected on the chat.
You're muted, Christina.
You're muted, Christina.
So sorry, there are only three that I can read. So Antonio Curicino asks, what to do in case they don't formalize continuing contracts despite the acquired entitlements and let a fixed term contract expire? This is one question.
I'm not sure I understand what does he mean with formalize.
Giorgio.
Or maybe I can further elaborate on that. Okay, there's a rule in WFP that actually says that when you go into your 6th year as a fixed term, including the probation, then the rule says shall be granted continuing contract. So it does not involve any decision, anything. I mean, provided that you have all your bases, your performance appraisal okay, and these 6 years, then you're entitled to get it. So the question is, what is, since HR now, what they're doing is, even for people who already served for 6 years, then they still do not formalize that automatically, even though the rule does not say that. So the question he asked is, what if they let this fixed term expire, and then even if the right was already acquired? So my question, my answer would be, the right is there already, so you should appeal. That's all.
Well, it does. The rule says that it shall be.
It should, yeah, it should be.
No, should be. It's very different from shall be. So it should be.
No, shall. So SHALL.
Okay, shall be.
Yeah,
okay.
yeah.
So it's a right to, after 6 years, to have your contract from fixed term to continuous appointment. Where, I mean, and the organization, the question is whether the organization is trying to delay this process and instead keep it as a fixed term. Well, I mean, if the right is embodied in...
No, the question from him was, what if they let this fixed term expire?
Instead
when the person already...
Instead of converting it in a
exactly.
indeterminate contract.
And Ludovica, if I can just provide some clarity as well.
Yes.
There's a limited number of continuing contracts within the whole common system.
Yes, yeah.
So that's the issue really, is that there's only a certain number of fixed term, continuing contracts or permanent contracts within the system. So even if the organization says shall, if they've reached the
quota,
their maximum, they cannot give continuing or permanent contracts. I hope that helps. And then back to you, Ludovica.
Thank you, Wazi. Yes, yes, indeed. I mean, this is probably what's happening. You know, that's there. And as I said during the presentation, organizations are not offering any more, open-ended contracts because they want to have the flexibility to terminate contracts or to let them expire. After according to the exigencies of service. Well, in this specific case, if there is, a right, is an employment right which is embodied in the staff rules. I think, you can definitely challenge the fact that you have not been given a continuous contract after, even if you fulfill all the requirements that are within the rules. So, there needs to be, justification from the organization in order to discontinue with this practice. It's not a practice; it's a right because it's embodied in the staff rules. So, unless the organization changes, the rules. But this should be a right that you can exercise. So if they don't, if you fulfill the criteria and you don't get a continuous contract, they need to provide you a justification. You can definitely trigger an administrative decision and requesting, why I'm not given a continuous contract. This would be my, answer without knowing the details and without having read the staff rules.
Well, in this case, it would be more like not an action, but a lack of action. But well, anyway.
Well, yeah, you would have to trigger a decision. You would have to request, like saying, pursuant to staff rules XYZ, I fulfill the criteria to be awarded a continuous contract. Yeah. So I'm hereby requesting, a change of my contract according to the staff rules. And the organizations then have to, explain the reason why this cannot be done. And this is a formal decision that you can challenge, of course.
Okay. Or if I may add, if this is already known at the time of signing the latest fixed term contract, when they propose to you, so you are at your 6th contract and they propose to you your 7th fixed term contract, you can challenge that one.
Yeah, well, that's for
but
sure.
This is that's outside the restructuring already.
Christina, do we have another question to read?
There is Mark who has raised his hand.
Hi, Ludovica. Hi, Laura.
Hi, Mark.
Okay, so look, I think the presentation is great, and I think it really highlights some of the things that we did and we didn't know already. And I think across all the organisations, there are some things that are slightly different. Yes, we at WFP, we do have what we call in the ad hoc framework, which contains a retention policy. Retention policy means that whereby, as in the cases of a restructuring and the abolishment of posts, there is a order of retention. Order of retention meaning that starting with affiliate contracts, consultants, short-term temporary assignment staff through to fixed term, indefinite, and then continuing being the last. So where I'm coming from is there was a question that I'm thinking that what more can we as staff representatives do apart from trying to ensure that the organization follows and adheres to its own internal policies, especially when it comes to the retention policy, because it's there in black and white. And we do have cases whereby as staff positions are being abolished, and we can't say it doesn't happen in the sense that, well, a manager says, oh, I don't like you, but I'm going to utilize this moment and this situation to restructure and abolish the position, knowing that who's sitting on that position, because at the end of the day, it's not about the people, it's about the restructure of positions and its operational restructuring. So, but behind all that, we do know it happens. So what I'm trying to find out is what more can the staff relations do when we are seeing this? And maybe sometimes it's about utilizing current case laws that you've really mentioned already, some of the situations with foul. But we're also saying, okay, if it does act, because what I'm seeing here, there's a subjectiveness in the way that the policies are being interpreted. Let's use that, because if it's in black and white, if you read in English, if it's written in French or Spanish, what it says is what it means. But there is this interpretation. So I'm thinking, from the staff representative point of view, we need to try to be more collaborative, but also identifying to the fact that this is what we're trying to do, trying to highlight, and say, hang on, the policy says this. If it comes to a fact that you have got the abolishing a position, and on the fact that you should be looking at keeping the continuing over a short term or over an affiliate, there are things that's coming out where it's been saying, well, we have understood that we may have a continuing at a G5, but a G6 position is higher, so we want to keep the G6 because of higher duties, but a G5 continuing, sorry, we're going to get rid of, even though they're doing the same kind of work.
Mm-hmm.
So we're finding a lot more cases like this, or we've got blatant where a position has been abolished through restructuring because we can clearly see that there a director or a manager wants to remove that person, so they're utilizing this. So I'm trying to work out what tools and what other means do we have to try and highlight this and to try and ensure that the organization follows this. Sorry, it's kind of been a bit long-winded, but I think I'm touching on areas whereby as there have been, I'm sure many of us who are on this call are experiencing and seeing this already. So what else more can we do?
Yeah, and Mark, just to add to that, Ludovica, the question is, how do we prove that the manager did not like that staff member particularly, right? So you had said the burden of proof is on, the staff member to kind of challenge the position. If I've had good performance reviews all the time, right? And it's subjective, and I know that this manager doesn't like me, but there's nothing anywhere in writing. My performance reviews are satisfactory, right? And maybe I do have a continuing contract or a permanent contract or whatever. So to Mark's question, I just wanted to add that layer, that how can we then help a staff member provide the burden of proof? Thank you.
Well, thank you, Wazit. Thank you, Mark. I mean, within the context of the judgments that we quoted before, where, of course, and this is a clear case where you have to demonstrate there is an improper motive, driving the restructuring, and it is a typical case where the restructuring is affecting only one person. So this is already, something that raises a red flag, because usually a genuine restructuring is affecting like more staff members. So it's like affecting the positions that are included in a team or in a department. When it's clear that there is the motive is actually that of getting rid of specific staff member. I mean, first of all, in response also to Wazi's question, I mean, the fact, I mean, the burden of proof that you're demonstrating already that there is no performance issue, your performance appraisals are positive. There is, the workload is distributed equally. There is no need to abolish this position, because actually it doesn't bring any benefit to the organization. So I think that those are the main aspects under which the staff association can help the staff member. So to show, basically, you don't need to find the proof that the manager doesn't like you or doesn't like the staff member affected, but you need to basically show the counter evidence that demonstrates that this was not a useful restructuring for the organization. There is no interest of the organization in at stake, and the staff members always performed well. There's no need to. So if they want to get rid of him, they have to rather do a performance management process that they cannot do because the performance is positive. So there's basically, the staff association needs to help the staff member to underline that the restructuring in this case is not the right path to use to resolve these kind of interpersonal clashes, which appears more like the case.
And I'm thinking, Ludovica, you're right. But again, if I use my thought pattern of that, it's about the position, not the person. Okay. If I abolish a position, I'm abolishing a position because of operational requirements. Yeah, be it financial or whatever to business. But then to look at the performance of that individual and to utilize that as a means of getting rid of the person, well, then you're moving away from the fact that you're abolishing a position due to operational needs.
Mm-hmm.
It's two separate. Yeah,
mm-hmm.
I should not be utilizing. Oh, I'm abolishing this position, and but he's got a bad performance. No, it's totally different. Yeah, the context is about the position, not the person.
Mm-hmm. Yeah, of course.
And it's just that the person sitting on top of it.
Well, as I said, you have to help the staff member in showing that the position is actually needed. I mean, that his position. Yeah. So basically, in other words, if you show that the position is needed and there is absolutely no need to abolish, you demonstrate at the same time that then there must be an improper motive to propose the abolition of that post that has to do with the person and not with the post. Because if the post is needed and it fits with the current structure, why would the manager like to abolish just that post specifically?
Yeah.
So,
I'm sorry, Ludovica.
Yes.
We've got 9 minutes left and we have hands up. So I'm sorry, Mark, could we move on to the other questions?
So
thank you, Christina.
Yeah. Pilar, please, it's your turn.
Okay, thank you, FICSA. Thank you, Ludovica and Laura, for this presentation. Excellent. So I have very concrete three questions. The first one is just to put you in the context. Pajo is going to be a restructuring. Probably we don't know exactly how many posts will be affected, between 60 and 50, 60 position, mostly G position and P2 position, and even the administration says that they are going to negotiate individually each case, right? So my first question is, what will be most efficient from the staff association perspective? Because will be for sure appellations, go case by case, individual case, or to join and join maybe similar cases and start the appellation in a maybe aggruppated by a common denominator or type of contract or something like that. So like more or less like a class action. This is the first one. The second is that the administration is proposing a change in the indemnities, trying to flexibilize the rules and regulations, how they are applied, and provide like a better option for the staff, but they are really not realistic. For example, they are suggesting to move from a state of the abolition of the post, so leave to leave without pay, so the staff can pay the proportion of the pension and health insurance, both of them, until the retirement. So this, I think, that should be look carefully just to be sure that there is no contradiction with the principles of that. This is the second one, if how we can ensure that these kind of measures are aligned with the rules and regulation. And the third one, and the discussion about this kind of personal aspect that could be involved in the abolition of the positions. Would you recommend that if any staff is fearing that the position will be abolished because of there is not good communication, or maybe they are feeling harassment from their supervisor, should they file a complaint for harassment before the abolition of the post? These are the three ones.
Okay, I will try to be brief and start from the third one. Well, I mean, of course, if you perceive a staff member perceived to be harassed, then of course should file a complaint against the supervisor. And clearly, if this complaint is filed before the restructuring takes place, it can show, or it can, I mean, if the complaint is substantiated, it can of course help in finding out that the proposed abolition was actually a measure to get rid of this specific person. This links as well to your first question. If there is only one person, subject to abolition, or a group of staff. So, of course, as a staff association, you can definitely assist the staff members, going with them, for example, as support person in meetings with HR. This always helps also in taking notes, and because sometimes for those meetings, staff members are very agitated and they're not particularly maybe noting down everything. So that your role would be that of course, supporting them. And of course, if there's more staff affected by the same restructuring decision, then of course it's less likely that it's a personal, decision. Is more of a, organizational need. And I mean, the role of the staff association is very useful if you coordinate, those appeals or grievances that arise from the same decision. And I always tell my clients when they come to me in more than one with the same problem, the more the merrier. Of course, the more you are raising an issue, the better this issue will be taken into account by the organization. So your role will be that of assisting. And then there was another question which I forgot.
It's about the proposed flexibility in the provision of entitlements.
Well,
so just to allow
in this case, in this case, of course, I mean, also you should accompany the staff member in the discussion regarding those, let's say, proposed package. But also, I mean, I would request administration to be sent those proposed amendments to the package, and of course, for your comments as staff association, to see whether they are not impacting acquired rights of staff. So I see other hands.
No, wait. Before that, I read a couple of messages. So Beer from UPU writes, I think that when someone is targeted and the seat to abolish is put under him or her, they will find a way, and that would lead to a trial. This is an experience at UPU. Then he says, I think that what you're saying is in contradiction with the broad discretion given to administrations by ILO at and UNAT, because obviously administration will keep saying that the organization needs to abolish positions. This is a comment. And then there is another question from Deng Johnson that says, we have noted that the structural adjustment is more subjective than objective. We saw G grade going home more than P grade, which is contrary to as it could sound well when there is a budget for P grade than G1. Sorry, I don't know if it is clear, but it's what is written. We saw.
Sorry, no, it's not clear.
We saw G grade going home more than P grade, which is contrary to DAS. It could sound well when there is a budget for P grade than G1. So sorry, I think it's meant that sometimes the decision targets more the grades. So there is not a balance between when there is
GNP.
Yeah, exactly. Restructuring at GNP are not treated the same way.
Well, that's, I mean, like, of course, one would have to see the circumstances of the specific case, but it is also true that in most organizations there are a lot of G positions, administrative assistants, and for example, there's a P3, and there are like 3 G staff reporting to the P3, and in the light of like cost effectiveness, sometimes it's the G position that it's probably not required anymore. So I don't know this specific case, so I cannot comment on that, but I don't think there is actually an imbalance between a restructuring G position or P position. I think when a restructuring hits, it hits everyone.
Okay.
And then regarding the other comment that I said something in contradiction, or it's not in contradiction. I mean, of course, the broad discretion of organizations is well established in the case law. But on the other hand, if there is an improper motive, this is something that the tribunal can assess. So there's no contradiction.
Okay,
Giorgio? It's difficult to demonstrate, but I mean that's another thing.
Giorgio, it's you.
Yeah, thank you. Okay, so I'll try to be quick. My question is about downgrading of positions. So I would like to know, I mean, this regardless the regulations of the different organizations, if there is any consolidated case law, especially in the ILO 80 about that, because I mean, I've been in the system very long time, and I actually cannot remember even one single person who actually got paid less than what he or she was paid before. Even though, for instance, WFP, the rules, they don't say that exactly, but I can't remember any of this happening ever. So I wanted
Giorgio,
to know if...
Sorry, you mean after a restructuring?
I mean, well, restructuring or not, if your position gets downgraded, basically say you are level, I don't know, 6, the position becomes level 5. Is there any specific case law or jurisprudence about that?
Well, first of all, it would be very complicated to do that within the same contract. You would be required to sign a new contract because I mean your grade is an acquired right.
Yeah, that's exactly. That's what I meant. But say, let's make an example. You have a continuing staff member or indefinite on a position, say ABC. That ABC position gets revised and downgraded from, say, level 3 to level 2. What happens? Does the person read? Yeah.
And the same salary, I guess.
Yeah, unfortunately, that is not what it's in the rules for us. So that's I wanted to know if there are any kind of consolidated jurisprudence on that from the ILO.
Well, I touched briefly upon it during the presentation that any changes to acquired right, they need basically to sign a new contract, and there must be a voluntary decision on the side of the staff member.
Okay, so basically you're offered this new position. If you accept, you go back. If you don't accept, you separate. Okay.
Exactly, and you get a termination package or a termination indemnity.
Okay, thank you. Then now it's clear.
Birham, it's your turn.
Yeah, thank you. My question is a bit in line with the previous one, but just in our case, we have staff that are hired for 3 years, and then there is a contract renewal. Could it be that, for instance, they have a P4 contract and they are proposed a P3 contract to do the same job? And in that case, they also have either to accept or to resign or to leave. What is it?
So you mean from a P4, they propose you to become a P3, basically?
Yeah, but because you have a 3 years contract and they say, okay, it's ended, but the new one is for P3 position.
Well, yeah, I mean, you can accept or you can decline the offer. I mean, no one is pointing you a gun to the contract, of course. But I mean, there are cases where, of course, people who want to stay on board for personal reason or they don't want to change job, they sign a new contract at a lower grade. I mean, it can happen. But yeah, as Laura said before, they cannot just downgrade you without, and paying you less. So, and as Irvan said, in case, your position is, let's say, downgraded to P3 from P4, you keep the P4 grade and pay, but your position is assigned then to the P3. But you keep, as it happened at WHO, as Irvan mentioned. But yeah, you're not under any obligation to accept a new position, a new grade.
Yeah, sorry, I would like just a precision. Just the case is the following. I am it's not me, but let's say I have a contract for 3 years that ends end of this year. And they say, okay, Mr. Fall, the contract is over. What we have, we can propose you. It's a P3. You do the same job, but it's a P3. I can accept or refuse, obviously. But if I accept, I am a P3 or a P4. A P3.
No, if you accept, you're a P3 in case of a new contract, because your contract as a P4 expired. So
okay.
And then you sign a new contract. Yeah.
So in case of a new contract, the administration is capable of, can have the liberty to propose me a lower grade. Okay.
Then of course you're not under any obligation to accept. Any other question we have?
So it looks like we don't have any other question in the chat, neither in the chat nor we have hands on. So maybe we can come to an end. No, Ahmed, please go on.
Oh, thank you very much. So I would like to ask, what's the timeline limits for each step? For example, I have checked WFP's Union for Fixed Term Law. And it says, as an internal, it says there are 2 steps. One is WFP Executive Director, and the other is FAO Appeals Committee. I think these are the 2 steps before ILO tribunal. So after we have advised those with these whole meetings or letters, what's the timeline? If there's a timeline that you have even witnessed in decisions, or
you mean generally in our experience, how long does it take to get a final decision?
Not only the decision, just applying to these levels. So, within which time frame I should reach to WFP Executive Director, because it's very hard for...
everything is written in the staff rules. However, if I'm not mistaken, because I deal with many organizations, it should be 60 days to send a letter, request for review to the executive director. And then upon receipt of a response, you have another 60 days or maybe more, I don't remember now by heart, to go to the appeals committee, the FAO appeals committee. Then once they will take a decision, issue a report, you will receive a final decision from the Director General of FAO, conveying you the recommendation of the appeals committee. And then from that moment, you have 90 days to go to the ILO 18.
So maybe, as I had no idea about all those steps or procedures, I pushed HR to just maybe it was a bit ambiguous, saying that, okay, please send my appeal to, or my petition to the highest level concerned. This is what I use as a terminology, because I had no idea about the procedure. But the response was a bit ignorance only. So can it be considered as observation of timelines, or just because I pushed HR only, even though they are ignorant, I observed how, I don't know how it can be interpreted on legal basis.
No, emails like follow-ups to HR are not considered requests for review of the decision. So you have to request a review of the decision that you want to contest within 60 days to the executive director. and there's no way to skip those, internal remedies available. So, and if you say that you didn't know, ignorance of the law is not an excuse. So you cannot be excused for not complying with the time limit.
Okay, thank you. And actually, normally our internal union of general service staff, this is our, normally they receive, as far as I receive from their website, they receive such appeals and passes through executive director or FAO committee. If I don't receive a response from the Union of General Staff in WFP, can I directly try to reach executive director?
So the staff council or staff union is not responsible to file your own grievance. So you should. I mean, I'm sure they're very helpful and they assist. They can assist you. But if they don't respond or they're not available to assist you, you should do it yourself. I mean, it's your responsibility to challenge a decision before, with the executive director requesting the review of such a decision. It's not the responsibility of the staff council.
Okay, thank you very much.
No problem. I see we have Fernando and Mark again.
Yes, and just a question: how much time do you have? Do you still have Ludovica and Laura?
Well, let's say 5 minutes, because we started 15 minutes later, so we have another 5 minutes because then we have a meeting actually at 4.
Okay, so next.
But I need 10 minutes to take a coffee.
Mine's just a quick one.
I thought Fernando was raising. I don't see the hand, but no.
I see the hand, Fernando and Mark.
Yes, I did raise. It's Fernando here.
Yeah.
Can I go ahead?
Yes, please, Fernando.
Okay, just a question. And I was wondering, because I guess you deal with both ILO-AT and you deal with United Nations Dispute Tribunal and the United Nations Appeals Tribunal. And I had 2 questions. One is the case law consistent? Because we're basically all have, the same working conditions and similar entitlements. And the other question I want to ask, do you consider that a 2-tier system is more protective of employees' rights than the 1-tier system we have at the ILO-AT? Because I'm with WHO, so we go to ILO-AT. And before, the UN only had the UN Administrative Tribunal, but now they have these 2 systems, with 2 tiers, which with professional judges in both, if I'm not mistaken. I'm just wondering whether it's more protective or less protective, or better due process to have a 2-tier system as opposed to ILO-AT, and whether or not this difference can be challenged or has ever been challenged.
Trust me, I try since at least 10 years to challenge this. The fact that the ILO-AT, the main difference is that, you still have 2 levels of redress. Internally at the organization, for example, at WHO, you have the GBA, right? So the Global Appeals
But the GBA,
Board.
there are no professional judges on the GBA.
The chair should be a legal practitioner or a former judge. So I think that usually in those internal appeals bodies, you always have a chair that is a former judge or a lawyer, or at least someone who has an understanding of legal issues. So you still have like a 2 level. Of course, in a system like the UN system, where you have the UNDP and then UNAT, or you have a decision-making body internally that then can be appealed before the UNAT. This is the main difference. For example, at IMO, at ITLOS, and other organizations that are under the UNAT system, their internal appeals body can issue final decisions. the organizations under the LOAT, the internal appeals body can only issue recommendations, and then the final decision is that of the head of the organization. And this is like something I'm trying to fight since at least 10 years, but the LOAT pretends to ignore me on this specific point. So basically, it's not that that's not true. I'm just joking. They're not ignoring me, and they're just like consistently saying that they are assessing whether the staff rules and regulations of their organization under their jurisdiction are applied correctly. So if the staff rules and regulations says that the internal appeals board is only an advisory body that can only issue a recommendation and the final decision rests with the DG, the SG, or the head of the organization, for them that's okay. So that's basically they do not intend to change this pattern for the time being. So this.
And in terms of the case law, I mean, do you see differences in terms?
Well, under some aspects there is consistency. I mean, there are like judgments that refers to each other's case law, and there is also a judgment that says that the judgments and the case law about international civil servants should be harmonized and consistent. However, we have examples where the tribunals took completely different views on some issues. So, for example, we all remember this famous case of post adjustment that the LOAT approved, and therefore there was, staff members in Geneva got back post adjustment, and the UN tribunal did not. So this is like a big, discrepancy in approach.
Okay, and there's nowhere to appeal to that.
No.
ICJ or
I mean, there are meetings at the LOAT level where I participated sometimes as well, and they request opinion on how to improve the system, but and of course I mean the objections and the topics are more or less very recurrent, but not much has been done so far to reach, let's say, the level of the UN system.
Okay, thank you.
You're welcome.
So Ludovica, it's up to you to decide if we stop.
And for those who are not present, that we're going to pass this information on to. So what I'm thinking of is that how can we collaborate because with the experiences that we're going to have today and what we've experienced now and what's going to happen in the future, I think there's lots of information that we could share back with you, Ludovica and Laura, of things that's happening, cases that's administrative decisions that's been made, the experiences the issues that we're finding that would actually help you because on the facts for your FAQs or whatever, and to give you a heads up and vice versa. So I'm just trying to work out what could be a good mechanism for us to share information. Is there a way that we've thought about that we can do or utilized to try and achieve this? Because I think it's great you've presented and it's kind of maybe one way, but I just think now we need to move to a point of collaborating more, and which is going to benefit both sides. Over.
Thank you, Mark.
Hi, Ludovica. Let me just answer that very quickly. Mark, you have us. FICSA, we do, that's what we do. We are the repository. And so utilize us, and then we will go to Ludovica after, compiling everything, because it'll be very difficult for them to, and remember, they are a paid service. so at least we as FICSA can.
We don't do it for charity.
Yeah, they don't do this for charity.
I was like, get your credit card out.
So very quickly, because we're ending soon, just utilize FICSA. We will put the recording of this on Ask the FICSA Experts. If there are any additional questions, please email them to us, and we can do a kind of compendium of the questions and just do frequently asked questions of this. And I think we'll do that anyway after the session, just questions that people have asked repeatedly. But one thing I wanted to make clear, there are certain policy issues that are not legal, right? So some of the questions we're asking are actually internal policy issues that the legal people cannot answer, and the others are actual legal questions. So I'm just going to hand over to Ludovica and Laura. We just want to thank you, and then Christina will take us out. I hope it answered your question, Mark, without, sort of, yeah.
Thank you, Badi, and thank you everyone for joining. I hope it was not too boring for you, and the questions were very much to the point. So thank you very much, and I see you at the next Ask the Expert. Not that I'm an expert on everything, but there might be a few other topics that we can see together.
Thank you, Ludovica, and thank you, Laura.
Thank you very much also from my side.
Yes, we cannot stop thanking you.